Well, guys, as you know, we love talking about big wins in the fight for gun rights in federal circuit court because what happens in one circuit can be used by gun owners in other parts of the country in similar fights. This video is all about a big win in the 10th Circuit just last week, which struck down New Mexico's 7-day waiting period on gun sales. I'm going to break down the facts of the case. I'm going to give you guys the details of the law, some great quotes from Judge Tymkovich, who struck this law down, and some of the asinine arguments made by New Mexico when they were trying to prove that waiting periods were somehow constitutional. Let's jump into this. If you've never heard of Governor Hrisham in New Mexico, she may be the biggest gun-grabbing governor that you've never heard of. Just last year, Governor Hrisham woke up one day and decided, damn the Constitution, damn the Supreme Court, I have the power, she thought, to sign an order which suspends the public carrying of firearms in the parks, in the city parks in Albuquerque, even if a person has a concealed carry permit. That's exactly what she did. It would be a criminal offense. We'd put you in prison, she said, if you're caught carrying in a city park, even if you have a concealed carry permit. Total derangement, hardcore, power-hungry gun grabber. Thankfully, the courts struck that down and tried to show her the limits of her power, but obviously she's not getting the message. So it wasn't a surprise when just last year, legislature passed and she then signed into law this 7-day waiting period. The way the law worked in New Mexico, 7 days was the minimum. You had to wait 7 days on any and all firearms purchases. And if NICS was slow for any reason or delayed, that 7 days could extend to 20 days. Now, of course, like any good gun control law, notice the sarcasm, there's all kinds of carve-outs for the government. Local law enforcement, state law enforcement, military, manufacturers, lots of carve-outs. But for the regular, everyday gun owner who wanted to buy a Glock 9 or a shotgun or a rifle for self-defense for themselves and their loved ones, we have to wait 7 days. And if we don't, we're facing criminal charges and jail time. The plaintiffs in this case, Samuel Ortega and Rebecca Scott, filed their lawsuit on day one, because they knew that not only is this unconstitutional, that waiting periods will get people killed. And we all know this, right? The only people who are impacted by gun control laws, whether it's magazine limits, waiting periods, or background checks, are law-abiding citizens. The predators who will, out there trying to rob, rape, or murder citizens, they just bypass those laws, and it makes their life even easier. So in this case, when they filed the suit, the plaintiffs asked the federal district court judge for two things. Number one, strike down this law on the merits. And number two, issue a preliminary injunction, which would block the enforcement of this law, because it takes time when you first file a lawsuit in federal court so you actually have your day in court. It can be a year. It can be up to 18 months in some cases. So in the meantime, they asked the court to block the enforcement of the law. Sadly, and I guess it wasn't a big surprise, the plaintiffs drew a really bad federal district court judge. And the judge in this case not only would not issue the PI motion, the judge actually said the law was constitutional. He said that the right to acquire a firearm does not directly relate to the idea of keeping and bearing firearms. And he even said the Second Amendment itself supports waiting periods or a cooling off period. So obviously a big loss in federal district court. That's not that big of a surprise. Don't be too alarmed by that. Most of the big wins that we've seen in the fight for gun rights over the last 5 years now begin with a lower district court judge, that's the bottom totem down here, saying siding against us. Then we appeal to circuit court, and in some cases, the United States Supreme Court. These are the three tiers of the federal court bench. So the plaintiffs, not dissuaded, appealed to the 10th Circuit Court of Appeals in Denver. And a 3-judge panel reviewed the case and ultimately sided with the plaintiffs 2-1 and struck down the law. The judges in this case were Judge Allison Ide, a Trump appointee, Judge Scott Matheson, an Obama appointee, and the head judge in this case was Judge Tymkovich, a George W. Bush appointee. I actually know a little bit about Judge Tymkovich. I had a case before him myself just 2 years ago. That case came out of Wyoming, where Wyoming gun owners, the group that I direct, was being told by the state to surrender the names of all of our donors. And we opposed that. The state came after us. They fined us. We then sued them in federal district court, had a so-so victory there. The case is appealed in front of Judge Tymkovich, who sided in our favor. He is widely seen as a very conservative judge in the area of the First Amendment, and sometimes, in this case, certainly in the case of the Second Amendment. Anytime you have a case in federal court about gun control, there's two main questions that have to be answered, a two-pronged test. Number one, does the conduct in question, is it covered by the Second Amendment? So in this case, waiting periods. Are these protected by the Second Amendment? Is it under the umbrella of the Second Amendment, or does it fall outside of the purview of the Second Amendment? If the issue at question, in this case, waiting periods, is a Second Amendment conversation, then the next question is there a historical analog, historical examples of similar gun control laws being on the books when the Second Amendment was ratified? Of course, this idea of historical analog came about with the Bruen case from the Supreme Court in 2022. Those are the two main questions the court was seeking to address in this appeal. So the first question first, does the Second Amendment cover waiting periods? Is this conduct of buying guns in waiting periods subject to the Second Amendment? Of course, New Mexico said no, that the process of buying or acquiring firearms was not the same as keeping and bearing. They literally claim the Second Amendment does not cover the purchase of firearms. So apparently in their mind, it's okay, and you're protected if you already own a firearm. That's keeping, right? That's bearing. But the process of getting it, that they said is not protected by the Second Amendment. It's just absolute crap. And thankfully, they lost hard on that in court. Judge Tymkovich gave a dynamite quote. He said, "Common sense dictates that the right to keep and bear arms requires the right to acquire arms." That seems like common sense. Just as the right to a free press includes the right to acquire a printing press, or the right to practice religion necessarily rests on the right to acquire a sacred text. So he blasted them and said, you cannot possibly be serious. The right to keep and bear arms certainly includes the right to acquire firearms. Then he kind of slams the district court judge. And a lot of times when I have seen circuit courts strike down or remand a district court judge on Second Amendment issues, a lot of times they try to be deferential. You know, a lot of times they're friends. They're all federal judges. They probably have the same retreats and vacations and professional development every year. They'll see these guys and gals at future judicial events. But in this case, the judge was not holding back. Tymkovich said, New Mexico's argument that limitations on firearm sales or transfers do not implicate the Second Amendment is just wrong. And the district court's engagement in limited means-end scrutiny is also wrong. So that argument came up and it was struck down hard. So then New Mexico pivots. And they say, okay, if it's covered conduct, okay, fine. But we only agree if the waiting period is too long. So a too long waiting period, that would be an infringement. But short, their words, not mine, a short 7-day waiting period, that's constitutional, right? And there's trying arguments out in open court. Tymkovich, again, just lowered the hammer. He said, so by New Mexico's ill logic, a restriction on firearm sales does not burden the Second Amendment until it does. This argument provides no limiting principles. It leads inevitably to case-by-case judicial interest balancing. So he's calling them out, saying, which is it? Is a waiting period constitutional or is it not? And if you're going to literally say it depends on the number of days, then it just comes down to whichever judge you get on the federal bench. He goes on to say, the burden imposed by a waiting period is brought into sharper focus when considered in the context of other constitutional rights. A carte blanche 1-week waiting period to publish a news story, unconstitutional. Temporary closures of churches during COVID-19, unconstitutional. Making defendants in criminal court wait 30 days after arraignment before seeking a lawyer, unconstitutional. The Second Amendment is no different. So bludgeoned them. This issue came up. He struck it down really hard. Case over, at least for this argument. So then New Mexico tries a different argument. So in the Heller case, which is the big gun rights case, the Supreme Court in 2008, the court said in Heller that we can grant that individuals have a right to possess firearms without addressing every single gun rights issue in the space. Specifically, Heller declined to address longstanding prohibitions on who could own guns. So New Mexico said, you see, Heller doesn't actually address this, so this is a constitutional action, making these waiting periods happen. But the court struck this down pretty hard because specifically in Heller, this is all in the context of commercial sales, not an individual purchase. The court said that New Mexico's waiting period law is not tailored to just addressing commercial sales. It covers all sales, even ones between like a transfer of a hobbyist to a friend, a collector to a museum. Like it incorporates all of these transactions. In the Heller case, the carve out there dealt with commercial sales. So they went on to say that this is also fails because waiting periods in this case are universal. There's no qualifications. The Heller decision, when they listed off the types of things they were not going to address, they said some people just can't have guns, convicted felons, those who are declared mentally ill, or you cannot carry in sensitive places like schools and government buildings. They weren't going to address those issues. But the court said in this case, those were very specific situations. The waiting period in New Mexico, that covers everybody and it's universal. That argument was struck down very hard. So then New Mexico pivots again and they say, okay, but the Ninth Circuit, right next door, California, some of their judges recently agreed that California's waiting period law was constitutional. So surely our 7 days can be good here in the 10th Circuit. But again, Judge Tymkovich, he basically laughed at them because he said, yeah, a dissenting opinion of a minority of the court held that California's law was okay. The majority ruled against California in the Ninth Circuit. So then they jump on to the next big question. Is there a historical precedent, examples, analogs of waiting periods in effect when the Second Amendment was ratified in the 1700s? And the Rahimi case from the Supreme Court from last year, it kind of modified Bruin. And it says you don't have to have an exact identical twin law, but there has to be something similar. In this case, Tymkovich said it doesn't need to be a dead ringer, but the state has to at least present us with a ringer. So he's getting kind of comedic in his decision. New Mexico argued that California had a one-day waiting period in 1923. Therefore, that was their historical analog that justified the continuation of New Mexico's law. But the court laughed at them because, number one, the analog, the historical example has to come at the time of the Second Amendment's ratification in the 1700s, not 1923. Further, the court said the California law in 1923 only was 1 day because it took 1 day to do a background check. It was not a blanket ban, and it sure wasn't a 7-day waiting period like New Mexico. So then they pivot again, New Mexico, the AG's office, and they say, okay, America had waiting periods on the books federally from 1993 to 1998. So that's an example. Again, the court laughed at New Mexico and said it has to be an example from the time the Second Amendment was ratified, not 1998. They also pointed out that the Congress sunsetted that law when NICS was adopted in 1988. So then they argue one more kind of, we'll call it a Hail Mary. They said that waiting periods generally are similar to licensing and permitting and other laws that ban drunk people from having firearms. And these laws all survived the Bruen case from 2022. So the courts have said some permitting, some background checks, some licensing is okay. And some people can't have guns, like people who are intoxicated. Therefore, New Mexico claimed the same type of law, waiting periods, should be allowed in New Mexico because the goal is to make sure that gun owners are responsible and law-abiding citizens. The court did not buy that either. They said a couple of things. Number one, they said even a drunk can get his guns back when he sobers up. There's no mandatory 7-day waiting period when somebody is intoxicated on when they can get their firearm back. They also said that the only way that this argument works is if anyone looking to buy a gun could be presumed irresponsible or not law-abiding. If somebody fit that category, that's one thing, but New Mexico could not prove that every single person who wanted to buy a gun was irresponsible and not law-abiding. Probably the stupidest and final argument that New Mexico made, and this one really is going to make you just like shake your head. They said that waiting periods are similar to typical delivery waiting periods that Americans were used to before we had FedEx and Amazon Prime and modern shipping methods. So I guess what their point was that back when you could buy a gun in a Sears and Roebuck catalog and it was shipped to you and it took a week or it took 10 days or 14 days, those delays were considered okay. Those delays were normative. So why can't we, New Mexico government, impose a 7-day waiting period? And the courts at this point were getting, I think, borderline pissed off with these weak arguments. They said necessary or unavoidable delays in the possession of a firearm resulting from ordinary physical limitations and private market forces are not prohibited by the Constitution. So they shut that down really hard. The last big quote from Judge Tymkovich, the final quote here, it was a very strong quote. He said, cooling off periods, or waiting periods, basically, do not fit into any historically grounded exception to the right to keep and bear arms, and they burden conduct within the Second Amendment scope. In this preliminary posture, we conclude that New Mexico's Waiting Period Act is likely an unconstitutional burden on the Second Amendment rights of its citizens. So this court did not just strike down with a tepid, decision these waiting periods. They body slammed it. And from there, it was sent back to district court to retry the case and to issue a new decision consistent with the opinion given by the Superior Court, in this case, the 10th Circuit. They'll also have to then consider the PI motion. And they basically, in the footnotes, agreed with the need for a PI motion, and they all but ordered the district court judge to issue that PI motion. So a huge victory in the context of the waiting period issue. And from here, there's a couple options. New Mexico has the decision now what to do next. Number one, they can appeal this case en banc. And what that basically means is 3 judges in the 10th Circuit heard this case. They can ask for the entire court en banc to listen to the case and hear the entire thing again. That's an option. The other option they have is to appeal directly to the United States Supreme Court. The third option is to simply shut up and take their beating. Now, there's no way they're going to go to SCOTUS and ask them to hear this case. New Mexico knows they would get their butt absolutely kicked in the Supreme Court if the case was even granted a cert petition. They might ask for an en banc review. It would seem that's possible. A lot of folks believe it's unlikely, but it could happen in this case. What is also likely, perhaps, is they realize that this law was ridiculously unconstitutional, and they simply have to comply with it. So we're going to have to wait and see what happens with this case as it progresses. But for every other gun owner in a state with waiting periods, if you've got litigation underway in your state, this is the kind of case your legal team can then use in a big way in your case. So a big gun rights victory. A lot of these are being made possible because President Trump stacked the courts his first go around with hundreds of conservative district court judges, circuit court judges, and of course, 3 big names on the United States Supreme Court. Hopefully, he has a chance to fill more vacancies, and a lot of them during his current tenure in the White House. We'll have to wait and see. Guys, that's all we have right now. Stay tuned for more information. In the meantime, stay safe and stay free.